Every single year, more than 100 million civil cases are filed in American courts. That is more than one case for every 3 people living in the United States. And yet, most people could not tell you the difference between a civil case and a criminal case if their freedom literally depended on it. Welcome to Legal Eagle Brief. Today we are breaking down one of the most fundamental distinctions in all of law, the difference between civil and criminal law. This might sound like basic stuff, but here is what will genuinely surprise you: the two systems can prosecute the same person for the exact same act, at the exact same time, under completely different rules, and reach completely opposite verdicts. That is not a loophole. That is intentional. And by the end of this video, you will understand exactly why, and what it means for you. To understand why these two systems exist side by side, you have to go back centuries. English common law, which forms the backbone of the American legal system, developed two separate tracks of justice because society recognized that not all wrongdoing is the same kind of wrongdoing. Some acts are offenses against the entire community, against the social order itself. Others are disputes between individuals where one person has harmed another in a personal, measurable way. These two categories require two different responses, two different processes, and two different outcomes. That distinction, baked into law over hundreds of years, is what gives us civil and criminal law today. Criminal law is defined by its relationship to the state. When someone commits a crime, it is the government, whether state or federal, that brings the case. The case title itself tells you this. You will see the people versus, or the state versus, or United States versus in criminal matters. The individual victim is not technically the plaintiff. The government is. This is because crimes are considered offenses not just against the victim, but against society as a whole. Murder, robbery, drug trafficking, fraud, these are treated as threats to the public order that demand a government response. Civil law, on the other hand, exists to resolve disputes between private parties. One person, company, or organization claims that another has wronged them in some legally recognizable way. The plaintiff brings the case themselves, at their own expense, seeking some form of remedy. That remedy is almost always financial. Civil law covers contracts, personal injury, property disputes, family law, employment law, and a vast range of other matters where private rights and obligations are at stake. But here is what nobody talks about when it comes to the burden of proof. The gap between criminal and civil standards is not just procedural, it is philosophical. In criminal law, the prosecution must prove guilt beyond a reasonable doubt. This is the highest standard of proof in the legal system. It is deliberately difficult to meet. The founders of this nation, drawing on English legal tradition, believed it was better for 10 guilty people to go free than for one innocent person to be wrongfully convicted. That belief is baked into the beyond a reasonable doubt standard at every level of criminal prosecution. Civil law uses a completely different standard, the preponderance of the evidence. This simply means more likely than not. If the evidence tips the scales even slightly, 51% versus 49%, the party with the greater weight of evidence wins. Some civil cases, particularly those involving fraud or punitive damages, use an intermediate standard called clear and convincing evidence, which sits between preponderance and beyond a reasonable doubt. But the core point stands: it is dramatically easier to win a civil case than a criminal one. This is exactly why O.J. Simpson was acquitted in criminal court in 1995 and then found liable in civil court just 2 years later. The criminal jury found that the prosecution had not proven guilt beyond a reasonable doubt. The civil jury, applying the preponderance standard, found that it was more likely than not that Simpson was responsible for the deaths. Same evidence. Same acts. Completely different outcomes. Completely legal. This is not a bug in the system, it is a feature, designed to protect individual liberty while still allowing victims to seek compensation. The consequences of each system are also dramatically different, and this is where the stakes become painfully clear. In criminal law, the consequences can include incarceration, probation, fines paid to the government, and in the most serious cases, the death penalty. A criminal conviction becomes part of your permanent record. It can strip you of the right to vote, to own a firearm, to hold professional licenses, and to work in certain fields. The state has the power to take your liberty, and that is why the protections in criminal proceedings are so robust. In civil law, the consequences are almost entirely financial. The losing party typically pays money damages to the winning party. These damages can be compensatory, meaning they are designed to make the victim whole, to cover medical bills, lost wages, pain and suffering, and property damage. In some cases, courts also award punitive damages, which are designed specifically to punish egregious behavior and deter others. The famous McDonald's hot coffee case from 1994 originally resulted in nearly $3 million in punitive damages, though that figure was later reduced. The point is that civil damages can be enormous, even without any criminal charge ever being filed. Now here is a fact that stops most people cold. In a criminal case, defendants have constitutional protections that simply do not apply in civil cases. The Fifth Amendment right against self-incrimination, for example, allows a criminal defendant to refuse to testify. In a civil case, the opposing party can generally be compelled to testify or produce documents under oath. The Fourth Amendment protections against unreasonable searches and seizures apply to government action in criminal proceedings. In civil discovery, private parties can dig deep into your records, finances, emails, and communications in ways that would be unthinkable in a criminal investigation without a warrant. There is also the question of who pays for the lawyers. In a criminal case, if you cannot afford an attorney, the government must provide one. This right, established by the Supreme Court in Gideon v. Wainwright in 1963, applies in any case where incarceration is a possible punishment. There is no equivalent right in civil cases. If you are sued civilly and cannot afford an attorney, you either represent yourself or go without. This creates a significant and well-documented disparity in access to civil justice, particularly for low-income individuals facing well-resourced corporations or institutions. But here is what nobody talks about: the way civil and criminal law actively intersect and interact. Prosecutors and civil attorneys can share information. A criminal conviction can be used as evidence in a subsequent civil case. Victims can file civil suits alongside or after criminal prosecutions. Regulatory agencies can pursue civil penalties and criminal charges simultaneously. And in white-collar crime, the government often layers civil forfeiture actions on top of criminal charges, seeking to strip defendants of every financial gain connected to the alleged wrongdoing. The two systems are not isolated tracks running parallel, they are deeply interconnected. Understanding this distinction also has practical consequences for ordinary people. If you are involved in a car accident, the other driver could face criminal charges for reckless driving and a civil lawsuit from you for damages at the same time, independently. If a business partner defrauds you, you might see both criminal fraud charges brought by prosecutors and your own civil case seeking to recover what you lost. If an employer discriminates against you, you might file a civil complaint with the Equal Employment Opportunity Commission while a separate criminal investigation proceeds. Knowing which system you are in, what it requires, and what it can deliver is not just academic, it determines your strategy, your rights, and your realistic outcomes. The bottom line is this: civil law and criminal law serve fundamentally different purposes, apply different standards of proof, impose different consequences, and offer different protections. Criminal law is society's tool for punishing conduct that threatens the public order. Civil law is the individual's tool for seeking justice and compensation when their rights have been violated. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Brief for a brand new video every single day. We will see you in the next one.